most of you have your cameras off. You do have the option to turn your cameras on if you would like to, but you don't need to. Everybody is muted for the purposes of the call this morning. We will take questions at the end, so if you do have questions, there is a group chat that you can post questions in to get into the group chat. If you just hover a mouse towards the bottom of your Zoom screen, you'll see a little bubble pretty much in the middle that says chat. Just click on that and that'll open up the chat bar usually to the right of your screen. And then at the very bottom, there's a place to type a message. So as we go along, if you have a question, feel free to type that question in, and we'll be answering those at the end. My name is David Feakes. I'm the owner and founder of the Parents Estate Planning Law Firm in Acton. Our firm is focused on estate planning primarily for parents of all ages and in all stages, from parents with young kids to empty nesters with kids who are getting grown and on their own. This is our April Pep Talk. We do this once a month. Pep Talk is our opportunity to share some estate planning concepts with you in a quicker, what we would say more digestible format. And today I want to go back to something that we've talked a lot about over the last weeks and months, and that is incapacity documents, primarily around healthcare. Right now, we're about, a little over 3 weeks into the stay-at-home advisory in Massachusetts. I think for a lot of people, we're settling into this new normal. We don't necessarily like it, but I think everybody's getting used to it. It seems more calming now than it was 3-4 weeks ago, when everything seemed to change, if not by the hour, certainly by the day. But we're also in the middle of what the governor and public health officials in Massachusetts have predicted would be the surge in Massachusetts, which they expected would be occurring between April 10th and April 20th. So we're right there in the middle of that. So I thought it would be good to go back and talk about healthcare documents and incapacity documents in general, so that people understand what they should have in place, what they need to have in place in case you get sick and need to go to the hospital, because certainly in these times, going to the hospital is not like it is in normal times. If you're going to the hospital, you're not going to be able to have visitors. They're not going to be able to drop things off for you afterwards or visit you. And so one of the things that we're going to share with you before the end of this meeting, and I encourage you to stick right through to the end, because we want to share a resource, really a non-legal resource, that'll help you to be prepared in case you have to go to the hospital. But let's talk about incapacity planning, what that looks like, what it means, how that can help you and will help you, and make things as easy as possible for your family if at some point you can't make decisions for yourself and you need someone to step in and make those decisions for you. And let's start with healthcare, because that's what's on everybody's minds right now. So essentially, there is a group of healthcare documents that you should have in place. There's a group of healthcare documents that we create for every single one of our clients as part of their comprehensive planning. And those documents include a healthcare proxy, a Hipaa authorization, and a living will. And we'll go back and talk about all of these. The first is a healthcare proxy. And here is the situation for everybody. And that is, if you go into the hospital, if you can't make medical decisions for yourself and you need someone to step in and make those decisions, if there's no plan in place, then most likely those people would need to get, at some level, court authority to make those decisions for you. Certainly if you're not married, without a formal plan in place, without a designation as to who could step in and make decisions for you, a court might need to get involved in granting what we call a conservatorship. And given the environment that we're in, where courts are not open the way they are traditionally open, although they are still functioning at some level. But with courts not being open, it's harder to get a conservatorship than it would be in normal times. So, and even for married couples, it is not automatic that a spouse is going to be able to make decisions for the other spouse who is sick. And certainly if you're not there in the hospital with them, all of this becomes far more complicated. So the best course of action, what everybody should have, is a healthcare proxy. That is the medical directive, the legal document that gives someone else the authority to make healthcare decisions for you if you can't make those healthcare decisions for yourself. For most people, it would be their spouse if they're married. Everybody should have an alternate as well in case their spouse is not available or their number one person is not available to make those decisions. So you always want to name a primary person, and you always want to name an alternate as well. And those are the people who would be able to step in and make decisions about your medical care if you were not able to make those decisions yourself, or if you were not able to communicate those decisions yourself. In Massachusetts, a healthcare proxy needs to be signed by 2 witnesses, and we'll talk a little bit more as we go along about how you can get this plan in place and what is required to get the formal plan in place. But it requires 2 witnesses who are witnessing your signature to make the document effective. So that's number one, a healthcare proxy. The second thing that's really, really important is what we call a Hipaa waiver or a Hipaa authorization. So most people are familiar with Hipaa, which is the Federal Medical Privacy Law, the Health Insurance Portability and Accountability Act, which essentially says that no identifiable healthcare information about you can be released to anyone but you without your express written consent. So often what can happen is if someone needs to make a decision for you, but they don't have authorization, there's not a Hipaa release or a Hipaa waiver in place, they might not be able to get access to the medical information that they would need to make informed and intelligent decisions about your care. So it's very important that 2 things happen. Number one, that your healthcare proxy have Hipaa compliant language within the proxy itself. And number 2, best practice is that you have a separate Hipaa waiver or Hipaa authorization that names those same people, the people you've given healthcare authorization to, so that they can access your medical records, so that they can communicate freely with your healthcare providers. So you want a healthcare proxy, you want a Hipaa waiver, Hipaa authorization, and finally, a living will is something that we include kind of in our healthcare grouping. And a living will is simply your guidance about how you want your healthcare decision makers to make decisions about life-sustaining treatment should you ever be at end of life with no expectation of recovering any meaningful quality of life. So if you're in a persistent vegetative state, or if you are otherwise terminal, unconscious with no expectation of recovering a meaningful quality of life, this is a document in which you can provide guidance to your decision makers about how to make those decisions. In Massachusetts, a living will is not binding authority, but it does provide basically a roadmap to your family, to your decision makers about how you would want those end-of-life decisions to be made. And I'm going to come back to a document that is like and closely tied to a living will that I often get questions on from clients and prospective clients, and that's the MOLST form. And I want to come back around to that. So in that healthcare grouping now, we've got a healthcare proxy, Hipaa waiver, and a living will. And again, for all of our clients, these documents are part of their comprehensive planning. But if you don't have a plan in place, or if you have an old plan that you think needs to be updated, I want to circle back to how we can help you get this in place. But I want to touch on one other document that is not directly healthcare related, but is tied into incapacity planning, and that's a durable power of attorney. And a power of attorney is a document that allows other people to step in and do everything not healthcare related. So to make all kinds of legal decisions for you, to sign legal documents on your behalf, to access your financial accounts, to manage your financial accounts, to manage things like your Zoom account or your Facebook account, to, if we were going to the post office these days, to go to the post office and pick up your certified mail, to do the kinds of things that you would otherwise do for yourself on a day-to-day basis. But if you're incapacitated, you wouldn't be able to do those things, and you would need someone to step in and do them for you. And a durable power of attorney generally gives someone else the authority to do those kinds of things. Sign legal documents, sign a tax return, sign a deed, walk into the bank and access your financial accounts, reallocate the investment mix in an IRA or a Roth IRA or a 401k, those kinds of day-to-day things. So that is something that we incorporate into our incapacity planning in the office as well for all of our clients. And that's something that you should have as part of your incapacity plan, is a durable power of attorney for those non-healthcare decisions. So one of the requests that we've been getting over and over and over since this pandemic started was, how can you help us get this in place? I don't have anything in place right now, and I'm worried about getting sick and needing to go to the hospital. And I want to make sure that everything is in place, that things are going to be as easy as possible for my spouse or for my family. Or I did this planning once upon a time, but it's been 10, 15, 20 years since this plan was put in place, and everything is different for me now. And the people that I named back then are not the people who would be good right now. And so we get requests to create these plans and to help people to update their existing plan, which essentially means recreating, because so much has changed. So that's something that we are available to help you to do. If you don't have a plan, or if you need to update an existing plan, the best way to get help from our office is to reach out to our client services coordinator. Her name is Lori Darling. There will be a link in the chat window to schedule a 15-minute call with Lori to discuss what we refer to as our COVID-19 planning package. And that's getting these incapacity documents in place. And click on that link and you can schedule a time to talk to Lori. She's waiting to talk to you. She is awesome. You will love talking to her, but she can walk you through how we can help you to get this plan in place. And by the way, if you are the parent or parents of minor children, the other thing that we add into this planning is essentially emergency guardians, so that if you ever have to go to the hospital, you've got people in place who can step in and take care of your kids if you need someone to care for them because you can't care for them. So just know, if you have young kids, that's something that we're looking at as part of that planning package as well. If you're the parent of adult children, obviously that's not a critical planning concern. So I wanted to circle back to one more thing, and then to offer you a gift that I discovered recently, and I think is a really, really great thing to have on hand right now, and even in the future. So the first thing I wanted to circle back to is the MOLST form. And this is akin to a DNR, a Do Not Resuscitate Order or form in Massachusetts. And MOLST stands for Medical Orders for Life-Sustaining Treatment. And in the chat box, we should be linking you to the website where you can download that form to either discuss with your healthcare provider, or at least to understand what it is. And mostly I get this question from existing clients where the form is not necessarily appropriate for them, because DNR and MOLST is more appropriate for either terminally ill patients or clients who are much, much older and would not want heroic measures if they were to become unconscious or have a heart attack or things like that. But people often ask about it, so I wanted to talk about it. And what the MOLST is, it is a form in which you can identify life-sustaining treatment that you either want to have or you don't want to have. And they break it down into categories: CPR, ventilation, transfer to hospital, and I have the form right in front of me, so I'm flipping over to the back side, intubation, non-invasive ventilation, dialysis, and then artificial nutrition and hydration. And the idea of the form is this is something that you would discuss with a healthcare provider or clinician, because it requires signatures by both you as the prospective patient and a healthcare provider who has actually discussed these treatments with you, so that you can make an informed and intelligent decision about whether you want them or whether you don't want them. And if you download the form, and it's at molst-ma.org, where you can download the form, or you can just Google Molst, M-O-L-S-T, space M-A, and you'll find the form in about 2 seconds. But again, I think the link is in the chat. There's instructions on what you need to do, how to fill it out, and it goes as far as suggesting how you would print this out. And what EMTs are trained to look for if they come into your house is a bright pink form with medical directives. And so on the Molst form, very interestingly, they not only suggest printing it on pink paper, but they're very specific about the kind of pink paper that you should print it on. And they even tell you, if you go to Staples or Office Depot, the SKU or the item number that you would look for at Staples or Office Depot to get this specific form of bright pink paper, which is called Astro Bright's Pulsar Pink. So that's what a Molst is. If you download the form, it's pretty self-explanatory. There is kind of an informational sheet on the 3rd page with important information about what it is, how to fill it out, and what it does. So the last thing I want to share with you is something that was shared with our firm recently from a friend and colleague of ours in Western Massachusetts, Paula Almgren, who I thank for connecting us with this resource. And that is essentially a packing list if you need to go to the hospital. How to create an emergency bag, how to pack an emergency bag, and everything that you want to have in that emergency bag if you have to go to the hospital. Because again, if you have to go to the hospital during this pandemic, no one's coming with you. Your spouse is not going to be able to come into the hospital with you. And once you're admitted to the hospital, nobody's going to be able to drop things off for you. So it's important to have these things ready and ready to go. It's almost like a pregnancy bag, to have these things ready and ready to go if you should need to go to the hospital. We are linking you to that form and that resource in the chat. And so I can see it's been uploaded there. You can download that directly from the chat window. It's a PDF form, and we just wanted you to have that resource because I think it's a really important one, especially during these times. And again, my thanks to Paula Almgren of Almgren Law. I always struggle with Paula's last name because I've known her since kindergarten, and I know her by a different last name the whole time I was growing up. But Paula Almgren from Almgren Law in Lenox, one of the outstanding elder law and estate planning attorneys in Western Massachusetts. And again, thank you, Paula, for sharing that resource with us so that we could pass it along to our clients and prospective clients. So again, if you want to get your planning done, or if you have any other questions for our office, the best way to get things moving forward is to schedule a call with Lori Darling, our client services coordinator. And again, the link to schedule that call is in the chat window. And again, that will get you a 15-minute call with Lori, and she can walk you through what it would look like to get these documents in place and how to get these documents signed in the environment that we're in now. And I should probably mention that before we get to questions, is that right now our office is closed. Our team is working remotely. Our clients, the work is being done as if we were all together. We huddle every morning, usually at 9:30. Today it's going to be at 10:30 because I was on the call here. Team gets together every morning by Zoom call. We know what we're working on, and everybody is working towards getting client work done. We're available for calls. We're available for meetings. We're doing reviews with all of our existing clients, again, by Zoom meetings. Signing documents has become more of a challenge. Number one, because we can't do it directly in person in the office, but we have set up procedures for doing urgent or emergency signings outside of the office in a parking lot. And a lot of estate planning attorneys have worked out a way to do parking lot signings or car signings or front porch signings. Most of the documents, in fact, all of the documents we talked about today in that COVID-19 planning package are available to sign outside of our office. As I said, the healthcare proxy requires 2 witnesses. A living will requires 2 witnesses, but the witnesses don't have to be inside our office. And so we can create these documents for you, get them to you, and give you instructions on how you can get it signed with your neighbors, everybody maintaining the appropriate social distancing. But all it requires is presence and the ability to watch someone sign documents, and then to have the witnesses sign as well. The other thing that we're watching very, very closely is there is legislation pending in Massachusetts for remote signings and remote notarization, particularly for estate planning purposes. There's nothing that has passed yet. I've been in contact with my state rep where I live, the state rep for Acton, which is where our office is, who is actually a co-sponsor of a House bill to allow remote authorization, and Senator Jamie Eldridge, who is our state senator for Acton. And there is legislation pending, and we're keeping our eye on it. But right now there is no authority for remote notarization, so we're not able to do that yet. But I'm hopeful that very, very soon we will be able to do a formal estate plan signing like this on a Zoom call, so that everybody can get everything in place. But just know that even though we might not be able to have a notarization with the appropriate witnesses, these documents are effective. And then we know when this is over and stay-at-home advisory has been lifted and non-essential businesses are allowed to reopen and we're back to more formal signing meetings in the office, we can kind of clean up anything that was not done the way we would have done it right from the beginning along the way. So apparently there is a question, and so I want to get to the question. I'm scrolling in the chat box. Let me find it. From Jesse, does the durable power of attorney need to be legally notarized, or do you need to go to court for this durable power of attorney? You do not need to go to court for a durable power of attorney, and it does not legally need to be notarized. So you can have an effective power of attorney without a notary and without witnesses. It just needs to be signed. Now, as a practical matter, we notarize durable powers of attorney, again, in normal circumstances when we're doing signings in the office, because it makes it easier to use the power of attorney if you're approaching, say, a financial institution. So for example, if your spouse had an account just in his or her name and they were unconscious in the hospital and you needed to get access to that account or needed to manage that account and you had a power of attorney, if it's notarized, you're less likely to get pushback from the bank when you show up on their doorstep with a power of attorney. It's as simple as that. So we do it so that it kind of smooths the process when the time comes. So there's less friction around that. So ideally it's notarized, but obviously right now, not always possible. Legally does not need to be notarized, although best practice is to have it notarized. Just seeing if there's any other questions in the chat. It does not look like there is. If you have any other questions, you can reach out to our office by email, support@parentsesstateplanning.com, support@parentsesstateplanning.com, with any questions that pop up beyond today, and we can get those questions answered for you. And again, if you want to schedule time to talk with our client services coordinator, the link is in the chat box to get time on Lori's calendar to talk about things. But otherwise, I want to thank you all for taking the time to be with me today. And I hope your family is well. I hope you are well. I hope you stay well. And as always, I know that we will emerge on the other side of this better and stronger than we went into it. And so I look forward to seeing you all as we come out of this, hopefully very, very soon. But in the meantime, if there's anything that we can do for you, don't hesitate to reach out to us. So thanks for joining me today, everybody. We'll talk again real soon. Take care.